in session.
Thanks. You may be seated. Good morning. We're here on our case number 1CACV 180256, Maricopa County versus the Ranas, or Ranas et al. Is Ascend a party to the?
Yes, Your Honor. They're defendant intervener.
Okay. Okay. Very good. Each side for this proceeding this morning is allotted 25 minutes, and we've put the amicus on the side of the appellants for that purpose. Unless you object or persuade us why we shouldn't go this route, we're going to invite counsel for the appellants and interveners to begin. You may reserve any amount of time you'd like to use, either in rebuttal to the appellee or in response to the amicus. Then we'll go to the county as appellee. You also may reserve time, if you'd like, to respond to the amicus. Then we'll go to the amicus. And then we'll see who has time left and go back to that. So given that the county filed a response to the amicus, you may follow that up if you'd like to.
Thank you.
The clock on the podium will reflect the total amount of time that is remaining for the amicus and the appellant together, or correspondingly the amount of time that remains for the county as appellee. You're in charge of keeping track of it for yourself. We have reviewed the record at some length, and we've studied the briefs. We've also discussed the case in our conference. Finally, when you approach the podium, we record these proceedings, so we'd be grateful to you if when you approach you would give us your name and the name of your clients for the recording. With that, you may proceed.
Good morning, and may it please the court. Spencer Scharf on behalf of appellants, defendants, Mr. and Mrs. Rana, and defendant intervener, Ascend Behavioral Health and Wellness. Joining me at council table is Rose Daly Rooney of the Arizona Center for Disability Law, who has agreed to address the Fair Housing Act issues after I present on appellant's other dispositive arguments. I will endeavor to reserve 10 minutes of time for the amicus party and 5 minutes for rebuttal. I would like to emphasize 3 issues today: the trial court's misinterpretation of the ordinance, the improper scope and reach of the permanent injunction granted, and appellant's equitable estoppel argument. First, the threshold issue before this court is one of statutory interpretation, which is subject to de novo review. Yet the county fails to proffer any interpretation that is consistent with the plain meaning of the group home ordinance. Neither the trial court nor the county points to any definition of the term care that does not encompass the types of services that are provided to the residents at the yearling home. At best, the difference between, quote, personal care, which the county contends is allowed, and treatment is one of intensity or degree. And nothing in the ordinance itself puts any limitation as to the intensity, degree, or type of care that is required to be provided at these group homes.
Would you help us understand what the kind of care, counseling, treatment is at issue here? What does the record tell us about the services that are provided to the residents that might take it outside the ordinance?
Sure, and I
understand you're saying it doesn't, but what's going on?
Sure, and I think the record isn't as well developed as the county who had the burden had to do, because the record where there is evidence of anything related to the services was done on direct questioning from the trial judge. And there, under direct questioning, there was a discussion of intermittent group counseling. There's no record as to how often it's provided, but that it is provided on site.
Sit in a circle, and there's a therapist or a counselor.
Exactly.
Okay.
But more often, the services that are provided are the licensed behavioral health therapists are providing the staff with the type of training so that they can provide the staff with the structure and the daily life skills that are necessary for the residents of the home. But again, there is no medical services being provided. In fact, it would violate the license of this home to provide such type of medical services.
So getting back to services given to the residents, other than group therapy sessions, what does the record tell us?
That's what the record says, that there's occasional group counseling, sometimes individual counseling sessions. Other than that, it's a ongoing daily life skills,
Okay.
Personal care.
Are the one-on-one counseling sessions given by, a social worker, a psychologist, or do we know?
It's a trained behavioral health therapist, yes.
Okay. All right.
And that's something that's kind of an odd thing in this case, where it seems as if the county's position is they want non-licensed individuals to be providing care to the residents. In fact, so it seems like to be like, and even though the ordinance says we must require to provide care from staff, they don't want to provide care at all. And we find that to be quite troubling. And the other position that the trial court adopts is that some treatment is okay, but too much treatment is not okay. How can a zoning department consistently and fairly enforce such a amorphous standard? We would submit that they cannot.
Well, isn't the county's position that no treatment is authorized?
That is the county's position, but yet there's no clear definition of what would constitute treatment. Under the judgment that was entered by the trial court, no treatment can be provided at all permanently. So if someone had an emergency, it would violate this order to have an ambulance come out and a doctor come out to anyone who lived there, whether they were a group home resident or not.
So, okay, so that's the care treatment
Yes.
issue. What about the concern that the Superior Court had about a couple of things, taking the home outside of the family-like environment? As I understand the record, the court pointed to business meetings that Ascend held at the home involving staff from other facilities, and also the practice that Ascend had of bringing residents from other facilities in for some purpose.
Yes, Your Honor. I'd like to respond to two issues. One is the record shows that the staff came to receive training related to the service they provided. It wasn't just like we were having, executive staff meetings.
Okay.
The more important fact is those meetings ceased when the county objected.
And does Ascend concede that it will not do that in the
Yes,
future?
if the court refers to the appendix 366, that is where the declaration from Ascend's executive director that was filed immediately after the trial court's order, where Ascend goes on record, signs under oath saying there hasn't been any meetings since the county objected, there will not be any future meetings at this home, and to the extent, even though Ascend believes it is in the best interests of their residents, they will not invite other non-residents to this home if it would be violate the zoning ordinance. Although it seems an absurd position for the county to take that having a Thanksgiving dinner would be a violation of the zoning ordinance.
So,
Does that appendix 366 document, are you conceding, if you will, that regardless of how this decision comes out from our court, that stands?
I think, Your Honor, that my client, and I think the record should reflect this, is not someone who's trying to shirk the rules and try to evade the rules. The operator is trying to follow the rules to the extent she understands the rules to be. That's why she went and got a group home permit, because she thought that is what she was required to do. And so if this court were to say you can't have a meeting at this home and that would violate the zoning ordinance, my client is 100% going to abide by any decision of this court and the trial court.
So put differently, though, I read in paragraph 5 of that affidavit, Ascend will not host any group events with non-residents at the home without first obtaining permission from the majority of yearling home residents or their legal guardians.
The notion of there is because they're independent, they're not in an institution, they're individuals who have rights, and if they want to invite their friends over, that they should be able to invite their friends over.
Nor will Ascend invite any non-residents over to the home, okay, without first obtaining permission.
Visitation, in other words,
And
visitation is
has-
what is it?
Has not
Exactly,
held a
Your Honor.
staff meeting. Put differently, does Ascend now object to portions of the injunction that would bar Ascend from doing those things?
From having individuals over, or for saying you can't have anyone over?
First, staff meetings with non-on-staff employees.
To the extent that the court finds that that's what the zoning ordinance says, we will follow it. However, we don't think there's anything in this ordinance that says you can't have, for example, if you had a home and you had a Girl Scout troop and all your daughter was in the Girl Scouts and you had the parents come in and they were part of the executive board of the Girl Scouts,
So
that wouldn't transform
to
the
drill
home.
down on your position before us, you're saying you would like to be able to hold these because you do not believe that they violate the ordinance, but should the court find that they do, Ascend is fine with proceeding as what I understand the status quo to be, which is that the meetings are not being held.
That is correct, Your Honor.
Okay.
That's correct. But again, I think the ordinance, there's nothing in the ordinance that says that wouldn't be an appropriate type of activity to occur. But again, my client has striven to follow the rules at every step, and in fact, is befuddled by how this process has proceeded. And before I reserve some time for rebuttal, I want to point out one quick thing I think is important in this case. This panel issued a memorandum disposition authored by Judge Perkins last month in another zoning matter out of Coconino County. That case involved over years inspections that revealed public hazards, a toxic cesspool. And there, the county gave the residents numerous opportunities to remediate the problem and didn't go into court and seek a permanent and preliminary injunction against that property, even though it clearly posed a public health hazard. It's the facts here are more befitting of a 19th century case than in 2019, where you have individuals who are simply trying to provide a home. And the last point, because I do want to reserve some time for rebuttal and for the amicus party, is that the court was struggling with this distinction between a hospital-like setting and a group home. And the court needs to look no further than the zoning ordinance itself for that distinction, because in its first phrase, it's a dwelling unit shared as their primary residence. A hospital is not a primary residence. Even a long-term inpatient facility, the individuals are ultimately discharged to the primary residence. The residents of the yearling home live there. This is their home. They have no other home. And with that, I would like to reserve some time for rebuttal, if it's okay. Thank you, Your Honors.
May it please the court, good morning, Your Honors. Wayne J. Peck and Chad McBride. We're Deputy Maricopa County Attorneys representing Maricopa County. Let me correct a few things immediately. The first one is these people are living in an institution. Because it is an institution, because they have a license from the state of Arizona for a behavioral health residential facility, which the state of Arizona defines as a healthcare institution. Now, in your questioning, Your Honor, I don't want this to sound pejorative, but fell into the same trap that apparently the defendants fell into, and that is concentrating on a family-like environment, ignoring the phrase that tells us what a family-like environment is. And a family-like environment is a single housekeeping unit, which is a well-known phrase in planning, as our witness testified.
Do we think that, is the county's position that the group home here is not a single housekeeping unit?
It is absolutely not
Why
a
is
single
that?
housekeeping unit.
Why is that?
Well, for example, Your Honor, on any given NFL Sunday, we can sit and watch the game, take our shoes off, lay back on the couch, and watch the game. The residents in Ascend cannot. On any, if the game is boring or it's frustrating, we can walk outside to clear our heads. The residents of the yearling home may not.
How does that get to single housekeeping unit?
A single housekeeping unit means that people act like they are a family. They have access.
Okay, what, you're bringing in the definition of family into single housekeeping unit. Let's
Well,
take the phrase by itself.
It's not by
Single-
itself, Your Honor.
Sure it is.
The definition in the ordinance is a single housekeeping unit, long-term, in a family-like
long-term.
setting.
Okay.
In a
But take
family-like
that
setting.
phrase first. That's how we do statutory interpretation. You take phrase, each word has to have independent meaning. What do those three words mean? Single housekeeping unit.
It means you have unrestricted use of the facility. It means you're not subject to things like searches. It means you can go into the kitchen to get a snack without
What does the
staff.
plain language mean of a single housekeeping unit?
Single
Does it
housekeeping
mean
unit.
a dwelling unit? Is this a single family house?
This is a single family house, but it says that they have to live as a single housekeeping unit. These people do not live as a single housekeeping unit. In our brief, we give you many examples, case law that says it can't restrict their freedom. Judge Warner said these rules so restrict their freedom that this facility takes on the characteristic of an institution,
What is
not
the best case that you can point me to that says a single housekeeping unit, that phrase, that part of this statutory scheme means you can't restrict their freedom? Where is the case that ties those two things together?
I'm sorry, I don't understand your question.
Well,
Your
you
Honor.
just indicated that you cited to numerous cases on single housekeeping unit, and that a core part of the definition of that term is the restriction or the lack of restriction on freedom. Where is a case that
We
provides
did
that?
cite the case in our brief, Your Honor, in which the court, there was a California court, and I promised when I reserve, I'm
Maybe
going
your
to
colleague could be looking for it right now.
reserve 5 minutes. It's community health, where the court described a single housekeeping unit to mean that the people were, that they shared common facilities. In that circumstance, they actually, they participate in household chores, which when they were asked, the only chore they could tell us that was going on that people participated in this house was washing dishes and mopping the floor under the supervision of staff. And it said they were free to come and go as they please. The people in the yearling home are not free to come and go as they please. They cannot open the windows.
Sir, this is an ordinance that's designed to accommodate residents for up to 10 persons who are seriously mentally ill. Doesn't the concept imply that there will be rules that are necessary to accommodate persons who fall into that category?
I would disagree with Your Honor that that's the purpose of the ordinance. The purpose of the ordinance is to provide a facility that is the functional equivalent of a single-family home, which is why it is allowed as of right in every single-family residential zoning district. Once the residents require constant treatment, which their expert testified they received, it converts from a dwelling unit to an institution.
Well, that's a separate, care and treatment is something else. You brought up rules being not consistent with a single housekeeping unit. I'm trying to drill down on that first.
Okay, Your Honor, it's not the county's position that rules are inconsistent. It's that rules that severely restrict your freedom. Every home has rules.
This group home were for youth ages 13 and 14, or 13 to 15, troubled youth. you're suggesting that there could be no rules, or that
No.
there could be no rules about that they're free to come and go from that home
According to the definition,
without just they can just take off.
well, no.
There's no curfew.
Rules that are the equivalent of rules that people would set in their homes for their families are no problem, and Judge Warner clearly distinguished between that. 13 and 14-year-olds.
We're not talking about, when we use the term family-like, let's go back to the family-like. Are we talking about the family that I have, perhaps? That's where I have been married to my wife for 30 years and I have 5 children? Or isn't this a family that's unassociated individuals? There's no relationship, so that it's not what you call the typical family, or what has been described as a typical family for centuries. That's not what we're talking about. We're talking about unrelated individuals.
Okay, if I may, Your Honor, the relationship amongst the people is defined as a single housekeeping unit. The family-like environment refers to the facility itself, so that it is a family-like facility as opposed to a hospital setting or an institutional setting. So we have never argued that this is not a family-like environment within the home.
Is there any evidence showing that this is not their primary residence? That the 10 people who live here, this is not their primary residence?
For the time that they are in the yearling home, it is their primary residence. However, their expert testified that the goal is to treat these people to the point where they can live independently. No, we are not disputing that for the people who live there, it is their primary residence. Just like people who are committed for a period of time, that's their primary residence.
If Ascend is barred, either agrees to or is barred from having staff members, staff meetings, business staff meetings on site, and is barred from bringing other residents from other facilities on site other than for visiting purposes, would the county then have any argument that the home is not a single housekeeping unit?
Yes, Your Honor, it would not be a single.
Why not?
Because they do not live as a single housekeeping unit. They do not participate in the daily operation of the house. They do not have a say in the rules. They do not have freedom of movement. They cannot go, for instance, into each other's rooms. They can't open their windows. They can't go into the kitchen on their own. They shower at set hours.
With the restrictions, the rules, kind of is an overlay that, as I understand your argument, informs your view on why the group home fails several elements of the ordinance.
That is correct, Your Honor. As I said, that is a planning term which is widely used. In the cases we cite, you will find, and in fact in the cases that the defendants cite, you will find most of the ordinances that deal with group homes and these kind of institutions use the phrase single housekeeping unit.
I guess I'm wondering how it can be that the zoning code could accommodate any group home involving minors or certain handicapped individuals, particularly people who suffer from SMI. How that could be, how the code can accommodate without the sort of rules that we're talking about. Is it your position that those people simply may not live in group homes under this code provision?
No, Your Honor. It's our position there are certain classifications within the classifications you've just given. Defendant's own expert testified that there are people who have serious mental illness. The two specific examples he gave in the record were schizophrenia and bipolar, who are capable of interacting socially such that they could live in an environment that, of course, it had rules, but did not restrict their freedom to the point that it converted what is supposed to be the equivalent of a single-family home into a healthcare institution. As I said at the outset, the very license that this operation has from the state of Arizona refers to it as a healthcare institution.
But isn't that proving what I just said? If your contention is that any group home is an institution, it's not going to be a group home.
No, Your Honor, no group home is an institution.
Well, you just said that.
This behavioral health residential facility, which is not a group home, is a healthcare facility, is a healthcare institution. That's the difference. We have many group homes throughout our Maricopa County for people who are elderly, for people who, individuals with disabilities and minors, where they live as in a group home. This is not a group home. Their own license that they obtained from the state of Arizona tells us this is not a group home.
So these other group homes don't have licenses?
Excuse me?
These other group homes don't have.
That is
the ones
correct.
you're-
And the reason for that is rather obvious. That the license that they've obtained is from the Arizona Department of Health Services. The Arizona Department of Health Services cares about how people who need health care are given health care.
Well,
If you live in a group home,
So are you saying that any operator of a group home under a license with DHS does not fall within the ordinance?
no, any operator who has a behavioral health residential facilities license from DHS would not fall within the definition of a group home. And despite the argument of defendants, the ordinance does not require a license from the state of Arizona.
Well, it seems to say certified by, registered by, funded by.
Funded by, and these individuals all are funded through Access. So that is a sufficient connection with the state under the ordinance for them to qualify as a group home if they live in a single housekeeping unit
But
and
I-
do not provide treatment.
Just thinking you need to be certified in order to provide those services.
No, I don't believe that everything that Access pays for has to be certified. There are a number of, according to the testimony in the record, there are a number of people who provide services to the residents of Yearling who do not have any kind of certification from the state of Arizona.
Is this license, DHS license argument something that you raised in the trial court?
Yes, Your Honor. It was discussed
Did
at
Judge
length.
Warner address it?
Excuse me, Your Honor?
Judge Warner address it in his order?
He did not specifically address it in his decision, but he did specifically say SMI individuals who can live in a group home as long as it operates like a group home. But in this particular case, which is the only thing that was before the court, what is going on in this particular case, this is an institution, and the county differentiates between group homes where people live, which the Department of Health is not concerned with, and institutions for the treatment of individuals, which the Department of Health is concerned with. And His Honor found that that was a distinction that made sense in the context of zoning. Just as the expert hired by the defendants found that the distinction between care and treatment, which is identical to the distinction made by the Department of Health, is a reasonable distinction. Care is care, treatment is treatment.
Do you disagree with counsel's description of the record insofar as what sort of services are being provided? I believe he said there are group therapy sessions and one-on-one counseling sessions by a behavioral health licensed person. Any other services in the record as being provided to the residents here?
To which the county takes exception, or in general? Because in general, yes,
To which the county takes exception?
No. And when the expert was specifically asked, their counseling.
Your contention is that group therapy and one-on-one counseling is something other than care.
That it is treatment, as their expert testified to in cross-examination. When I specifically asked him, is that treatment?
Why is it that we should interpret the ordinance as barring a service that doesn't fall within the meaning of care?
Because, Your Honor, the zoning ordinance is a permissive ordinance. It tells you what you can do, which means if it doesn't say you can do it, you can't do it. For instance, in a commercial zoning district, which parenthetically is a district where the Ascend facility would be allowed as of right in Maricopa County. There are 5 zoning districts which allow it as of right. For instance, in a commercial district, it might say you can have a dry cleaner and you can have an art gallery, but that doesn't mean you can have a real estate office unless it lists it, because as the courts have said with connection to permissive zoning ordinances, really it's hard for a municipality or a jurisdiction to anticipate absolutely everything. So what we say in ours is these uses are only these uses are permitted. Only care, training, and support. If you look at the definition of a hospital, for instance, in the ordinance, it says treatment. If you look at the facility for certain animal care, it says treatment. They are two different things. And as I indicated, the Department of Health regulations differentiate care and treatment, and their expert testified that is a reasonable distinction.
What is the authority for the proposition that group therapy sessions and one-on-one counseling is not care?
It's the testimony of their expert who was qualified in the area of behavioral health. When I asked him if these counseling and therapy sessions are treatment, and his answer was, yes, sir. Now, throughout the...
Why do we turn to an expert to tell us what an ordinance means?
It wasn't our expert, Your Honor.
Well, I know, but why? We never do. We do that when we interpret statutes. Do we hire experts to tell us what statutes mean?
Well,
I mean, we being the public. I mean, the lawyers do look in cases. I'm not aware of a single case. Maybe you can point me to one where our court or the Supreme Court has relied upon what an expert witness has said to ascertain the plain meaning of a statute.
I understand, Your Honor. However, this case, which is really a simple zoning code enforcement case, deals with the interpretation that was made by the department, which is the entity by statute that decides what its own ordinance means.
Right, but we
and
don't.
The
but
question
we do,
in
but
that is
Arizona case on our Supreme Court told us this a couple of years ago. And reiterated again, we don't go to secondary tools. We don't look at what the department thinks unless we find the statute ambiguous. Is it ambiguous? Is the code ambiguous?
No, we don't believe it is, because
then what does the plan? Then what is the definition of care and what is the definition of treatment, and how is there no overlap whatsoever between the two?
Care is assistance, according to statute. Care is assistance with the daily activities of living.
What statute? I'm sorry.
36. It's under the health code. I know it's cited in our brief, and it is referenced in the transcript. I'm sorry, Your Honor, I don't know the site.
So that's the definition. Okay,
it's daily. It's like helping people into bed, out of chairs, combing their hair, brushing their teeth, reminding them to shower, reminding them to take medication. Treatment is something that's designed to palliate or cure a medical condition. That is totally consistent with what their expert testified went on there.
Where do you get that definition?
That is in the regulations. It's I believe
also in the same regulations where you're getting the care definition.
That is correct. And I know that the care is, I believe, subsection, I don't remember. I know the treatment is subsection 209
Of
the regulations, which is, I think, 9, 10, 101, something. Again, those are cited in the brief, and those regulations were actually a trial exhibit. According to this, I have 5 minutes and 23 seconds. I'm happy to answer questions, but I would like to reserve some time to discuss the amicus brief.
Thank you.
Thank you.
Rose De La Rooney for Amicus, Arizona Center for Disability Law. It's undisputable that local government may regulate land use, but they may not do so at the expense of the Fair Housing Act. And this county's interpretation to say that a home that provides any treatment or more than occasional treatment, as the court said, is an impermissible discriminatory factor. And it is then used to treat people with disabilities differently. So if you people with disabilities are more likely to be people that need treatment than other unrelated groups of people. And if you treat people with disabilities differently and you don't allow them who need some in-home treatment and you don't allow them to be a group home, that is a non-conforming use of a group home, then you make them a group care facility. A group care facility is not allowed as a matter of right in any zoning district, regardless of what the county just said. If you do a word search of the county ordinance and you search group care facility, it will appear 3 times. It appears twice in definition. It appears the 3rd time in the special use permit that says you have to get a special use permit. It doesn't say it is in the hospital sections. Their county zoning director testified that they could locate in a hospital setting. But as the county's attorney just said, if it's not listed in the commercial district, you can't be there, and it's not listed. Group care facilities.
So you're saying under that construction of the ordinance, a group care facility, it may be authorized only by a special use permit anywhere?
Right. Anywhere. And because when you go to the commercial zones, it does say hospital, as the zoning director testified, but it does not say group care facility. Additionally, the group care facility, the other things in the group care facility that other special use permits are kennels, farm clinics, farm animal clinics, and those are the same communication towers. That's who has to go for a special use permit, and so do people in group care facilities. So if a group under 10 that would be like other groups was in a group home, it can't be, because it's still primary residence, it's still under 10, it's still a single family housekeeping unit. But because some or all of the people need treatment, it has to go into a group care facility.
And doesn't the county respond to this by saying the only issue the county has with that is where the treatment is provided? And this is the thing where the court and the county and the court take the position that you can be in a group home if you are. You can be in a group home if you act like a group home, but you can't act like a group home if you're in a residential behavioral health facility. They have used discrimination by proxy. They use homes that require treatment, homes that are a behavioral health facility. They use these as a proxy for serious mental illness. Because if you want to get a license, they say that you don't need a license. You do need a license if for people who are seriously mentally ill and who are covered by Access. They get these services. They're paid for by Access, but you can't receive money from Access unless you meet the requirements. And the county ignores the fact that there are county regulation. They have created an impossible conflict between state and local law. Local law requires them to be licensed or funded. They're not going to be funded unless they're licensed. They must get a license. And then the state creates requirements for that license. Those requirements include some of the things they object to. You're supposed to have the Arizona Administrative Code, R9-10-700, same sections, same general sections they're quoting. They need to have, if you're 10 or more, you have to have a clinical director. If 10 or more or 10 or less?
10 or more, you have to have a clinical, and they had the capacity yearling home for 10. So when you have a behavioral health facility license, you have a capacity. It's on the face of it. It's in the record, and their capacity was 10.
What license does Ascend have here?
It has a behavioral health residential facility license. That is a label. It is just a label. If you can, yes.
And that's given by DHS?
That is correct.
And where would we look, if you know, to find in the code what obligations that license imposes on Ascend?
It is at our Arizona Administrative Code R9-10-700, and then in the range of 700. Those each of the different types of facilities will have their own set, and that's the set for rehabilitation, for behavioral health rehabilitation facilities. And that includes some things like having a licensed professional counselor available on call, and here they use them to do some one-on-one counseling, some that. People have to have treatment plans, but treatment is defined to also include behavioral health services by behavioral health technician. This license doesn't have, they have to have a scope of services. The scope of services does not include medical services. They receive they receive their psychiatric care, their counseling, the record showed off-site. They went there. What they received was someone supervising the BHTs and providing guidance to the BHTs.
Behavioral
and
health
technicians, Your Honor. So they have created a construct, and that is why the Arizona Center for Disability Law wanted to file an amicus in this case, because we are concerned not only that if a place like Yearling Home, that is number one, it's licensed by the state, it's gets voluntary accreditation from CARF, which has higher standards. It has no founded complaints against it. None of the non-conforming uses have anything to do with how the residents are interacting with their neighbors, and the only non-conforming use is meetings and things like rules. I would add that, just quickly, that rules are not a land use. Under the Fair Housing Act, they should not be a land use issue. Rules, all of these individuals who are SMI and live in a group home, they have rights. If they don't like a rule, they may challenge it. They have appeal and grievance rights. That is a requirement that these behavioral health facilities have to do, and they have done it by they have to meet that as part of their requirements. And people have the right to challenge rules, and they have rights to privacy. They have rights to they have all kinds of rights, and those are listed there, and they must account for them and allow them a complaint procedure as well as a separate external appeal and grievance procedure.
What I understand the county to be saying is that because SMI persons may live in a group home only under a certain sort of license from the state, that license requires the group home operator to give certain services that take that group home outside the ordinance. You told us how Ascend is licensed or has licensed this group home. Is there another category of license that a group home operator might receive that would allow the group home to care for SMI persons within the ordinance as the county understands it?
Not really, Your Honor. There is there's one category of respite which doesn't count because it's not the permanent thing, and then there's one where people can move into someone's home like foster care, like adult foster care. But there's not a group home. That is the label for all facilities. Now there will be, because they have capacity listed on it, and you can tell which belongs in a neighborhood like a single family and which don't because it's their capacity. There are a smaller percentage of them that are of this category that are licensed for a larger number, but they wouldn't belong in there based on size. Right. And that's the way to be able to do it. And they are intended to be like a home. Yearling Home is, as their expert indicated, one of the best he's seen in 30 years of career, and that's the one that they're trying to get rid of. Thank you, Your Honors.
Thank you. Start with the appellant.
I'd like to have the last word as the appellant.
Pardon?
If the court would permit to have
All right.
the appellant
All right.
have the last word.
Thank you.
Sorry, I don't know the rules that way, Your Honor.
Pardon me?
I'm sorry, I didn't know the rules.
Well, we're making this procedure up as we go, so.
Okay. I'd like to address the very last question that was just asked. And the question was, is there another license for group homes? The state does not license group homes other than for minors in certain circumstances and for the developmentally disabled. And the reason for that is the Department of Health is not concerned with how people live. That's covered by things by zoning ordinances and building codes, etc. They care about how people get health care.
So does the ordinance allow any group home environment for SMI persons?
Yes.
How would that happen?
Any SMI individual who does not need constant treatment, as their expert testified,
Is
there
it constant or any treatment? It
Excuse
seems
me?
to be that this county's position is any treatment.
Well, that's, as Judge Warner said, if somebody gets sick and they call the doctor in to examine, I guess Judge Warner and I remember when doctors made house calls, that's fine. You can do that kind of treatment. If someone falls down and skins his knee, you can give them Neosporin.
What about-
This is a treatment center because their license says it is.
But don't you need a license from DHS to house SMI persons?
You need a license from the Department of Health to house certain SMI individuals, those who cannot live independently. Group homes are for people who basically live independently, but they need care and assistance. It's like an assisted living facility for fewer than 10 residents would be a group home.
Counsel, what about for developmentally disabled?
That's by separate statute.
Oh, that's part of the same ordinance.
No, our ordinance does not include,
It excludes
specifically
the develop-
excludes
Okay,
those
sorry.
from the
Or
definition of group home.
autistic, which
Okay,
is
my-
another issue.
I got it.
Not a problem. This is zoning, and
Sure.
not everybody is as familiar with zoning as I am, unfortunately for me.
But
And-
so what I hear you saying though is a group home may accommodate SMI persons only if they're capable of living independently.
to a degree of independence, yes, just like seniors,
What is
If-
that degree?
that they don't need a license from the state of Arizona to be in a healthcare institution. If I can read to your honors from the brief of amicus, it says at page 10, a behavioral health residential facility is a healthcare institution that provides treatment to an individual experience a behavioral health issue. That's what this is. This is a healthcare institution. This is a zoning enforcement case. We allow group homes that operate like group homes to exist in all residential zoning districts. Group healthcare facilities go in the C2, C3, IND1, IN2.
Done that.
Okay. The statement by the amicus was just absolutely false. Those are allowed as a matter of record. There is, in fact, a directive from the department that says healthcare facilities that aren't group homes are the equivalent of hospitals because they are healthcare facilities, not because Maricopa County says so.
I'm trying to understand how the ordinance, what kind of an environment, what kind of a group home could exist consistent with the ordinance for group home, for SMI persons. And as I understand you, that would be if you could allow residents who, they don't need to be licensed by, certified, funded by.
Correct.
So their housing is funded by Access?
I don't know the access rules. All I know is the testimony was that the individuals in the yearling home are funded by Access. For us, without a state license, that would have been sufficient.
But Access is a medical insurance plan that provides
But there,
treatment. I mean, how does that?
I don't know what state funding may be available for the types of individuals who can live in a group home. All I know about Access is that was the testimony. And our point is, in this particular case, because that's all that's before the court, is this particular situation, is it or is it not a zoning code violation?
And
that would be sufficient.
What I understand you're saying is any group home operator that's licensed or certified by DHS is going to fall outside the ordinance because by definition, you say it's going to be providing treatment.
No. because a group home may get a different license. We don't know all the licenses that are available. All we know is in this case, they have a behavioral health residential facility license, which the state of Arizona says makes this a healthcare institution. That's how they have jurisdiction over it. I don't know what I know. For instance, there's a bill pending in front of the legislature that would offer regulation and licensing of group homes. But as of now, as far as I know, there isn't any licensing except for specific types of group homes. But there may be licenses that apply to assisted living facilities. I don't know. I'm a zoning attorney. I am here to tell you what they are doing violates the zoning ordinance.
Because the counseling that's offered is treatment, not, you got the rules issue, the business meeting, and then you got the counseling is not care but is treatment.
Yes, if I could just quickly point out, the county never argued to the court that it was not a single housekeeping unit because they had these meetings. That was very ancillary. What we focused on were these rules that restrict the freedom is what takes it outside of the definition of a single housekeeping unit.
Okay. No questions from him? Thank you, sir.
Thank you, Your Honor.
Thank you, Your Honors. A few quick points I'd like to follow up on. One is, and I can be happy to help the county here, with the statute he's referring to is 36-401, paragraph 36. That is the statutory definition for personal care services. That statute also contains definitions for directed care services, respite care services, supervisory care services. Again, those adjectives are not found in the ordinance. It just says care. And there's nothing in the record to support the notion that we should limit it to personal care. This just evidences that care is much broader than the county presents it. Two, if the county's current position is you have to be able to live independently, would seem to be not consistent with their own ordinance that requires staff on site. How could a home have everyone who's living independent and yet still require staff? The point of the staff is these are for homes where individuals need assistance living independently, just as if a home for minors would need assistance living. And if the position of the county was so, it seems to be clear, right, the way they're presenting it. If it's a behavioral health residential facility license, it cannot constitute a group home. If it is so clear, if the ordinance is so clear, why is it that in 2017, when my client was trying to comply with the zoning ordinance, and the county, and the record is clear, they have emails from the Department of Health Services that this is a behavioral health residential facility in February of 2017. They sign a compliance agreement in July of 2017 that gives them a zoning clearance which defined by the ordinance is, quote, a issuance of a permit by the zoning inspector indicating that a proposed use of land meets all the standards contained in the ordinance. If that's the case, and they knew this was a behavioral health residential facility, why did they approve that zoning permit in 2017? Because it isn't that clear. And
make of your expert's testimony that on-site counseling and therapy is a treatment.
Dr. Franzak wasn't speaking in terms, using the terms as the ordinance used it. He was using it in terms of how a clinical, someone who was for 11 years, the head of clinical service, Department of Health Services, he wasn't saying he didn't say treatment is not care. He was just using those terms interchangeably. And that's how I would respond to that. And I'm confident Dr. Franzak would agree with that. The other thing that Dr. Franzak did say on the record, and that's at Appendix 235, is that there is no other way for a home to get approval from the state. There's no other license or way to get funding without this behavioral health residential facility. It's the only one, and he said hundreds of homes would be shut down if this was the way it was interpreted across the state.
So you're saying that he answered my question, which is how else can a group home accommodate SMI persons?
Yes, Your Honor. And that's at 235 in the appendix. And more importantly, the notion that there's other means other than licensing, that is not in the record. That was never raised by the county, and we would have certainly addressed it. The county had taken the position that you had to have a license. And yes, the ordinance has other ways, but the position the county had taken was you needed a license. So they've created this scheme that makes it so it excludes individuals with SMIs. And the funding issue was raised, but that was the first time I saw it was in the county's response to the amicus brief ever raised. There was a way you can get funding through access without a license. And the record is crystal clear. This is an excellent home that provides excellent care, support, and training to its residents. And I would like to echo the statements of my colleague from the center. If this home is a home that justifies this much government animosity and fun to shut down, what other home could possibly exist and possibly withstand? This is a very heavily regulated home, and for good reason, because these are individuals who are vulnerable adults. And my clients take that responsibility very seriously. And that's why, again, they are just frustrated and befuddled that they could get in this much trouble, and this is where they perceive to get in this much trouble, just by simply trying to follow the rules.
Is this, and they fall into the ordinance by definition because as SMI they're, to use the word in the statute, handicapped?
That's correct, Your Honor. That is correct. And that's one of the reasons why I kept bringing back the request for admissions into the record, because I thought it really colored the county's position. They refused to admit that a person with an SMI was capable of living in a family-like environment, despite the fact that that was one of their allegations in their complaint.
Okay.
And we find that very troubling.
All right. Further questions?
We really appreciate your time, your consideration.
Likewise, thank you to all the lawyers for your briefing and your argument. We'll take the matter under advisement and issue a decision in due course. Now we'll adjourn.
Thank you, Your Honors.
Thank you.